I'm Tyler Souters in the Energy News Center. February 16th was the deadline for challenges to the EPA's endangerment finding regarding greenhouse gases. And there are now 16 court challenges in place now that the deadline has come and gone to address that issue. Joining us now to talk about the where-tos and why-fors is Dick Stoll. You've seen him before on Clean Skies News. He is an attorney and partner in the environmental practice at Foley and Lardner here in Washington. Also a former EPA attorney. I want to get that in there as well. Dick, good to have you back with us.
Okay, glad to be here, Tyler.
Let's run through quickly one more time the process here, legally and officially. The challenges are in place, the review goes to the Circuit Court, and then potentially the Supreme Court.
Yeah, EPA issues a final rule, and that's what they did in the December 15th Federal Register, this past December 15th, the endangerment finding. That is a final rule under the Clean Air Act. That means that parties who don't like it, want to challenge it in court, have 60 days to go to the U.S. Court of Appeals for the D.C. Circuit, and that's the only place they can go. And that's happened now. So the 60 days have passed. 16 different parties have filed petitions for review in the D.C. Circuit, and now the court will look at the arguments that the parties are making against it, and the court will ultimately decide whether to uphold it or not.
Okay. Among those 16 claims, Dick, some of the expected ones from industry, a pretty broad range here. Utilities, refiners, coal and oil, steel and cement.
Yep.
But one of the arguments that sums that case up best to me, Dick, comes from the president of the National Association of Manufacturers, John Engler, and quoting now, he says, if EPA moves forward and begins regulating stationary sources, it will open the door for them to regulate everything from industrial facilities to farms to even American homes. Is that the crux of the argument, that this regulation, if it is adopted, will simply be too broad?
That's one main issue that the parties have. Now, that's not the only issue, but that's a big issue. And despite the fact that EPA says that they would like to limit their regulatory program to sources of air pollution that are really quite big, like they say 25,000 tons a year or maybe even more, that their ability to keep it at that 25,000 tons is very suspect under the very words of the Clean Air Act. And so the fear that a lot of people in the industry and NAM rationally have is that once EPA goes final with this new tailoring rule, which is following along here, and establishes a 25,000 ton threshold or a 40,000 ton threshold or whatever, that will be reversed by the D.C. Circuit as unsustainable under the very words of the Clean Air Act, and then you really will be getting into homes and restaurants and small farms and whatever.
What about some of these other parties? And this is a little bit more unusual in my view. 3 states are joining this filing suit: Virginia, Alabama, and Texas. Does the fact that these are state entities change or add weight to these challenges at all?
No, in fact, what we've seen over, I'm going to say, the last 10 years of litigation in the D.C. Circuit on EPA rules is it seems that states take sides. And this has happened over and over again. I mean, remember, by the way, that the Supreme Court case that started all this greenhouse gas is Massachusetts versus EPA. Yeah. So this, for political reasons or whatever reasons, states often jump in and take sides. Now, there have also been, you mentioned the 16 suits filed against EPA here. Parties are now starting to intervene. The intervention deadline is 30 days later.
And these are parties essentially siding with EPA,
yes,
supporting the position.
Yes, and some states have intervened on EPA's behalf, and also significantly, a group of environmental groups, the Natural Resources Defense Council, Sierra Club, Environmental Defense Fund, and National Wildlife, have all filed intervention papers. And they've been in the middle of all this regulatory and litigation play for years. So we're going to have every side of the issue presented now in the D.C. Circuit.
And with all these parties going forward in such a complex issue, Dick, what is the timeline here? And I ask because when the endangerment finding was announced by EPA Administrator Lisa Jackson, she said that these long overdue findings cement 2009's place in history as the year when the U.S. government began addressing the challenge of GHG pollution. Cements 2009's place in history.
Okay.
That's when the announcement comes, December 7th, I believe.
Yep.
However, this is going to play out for a long, long time before there is any potential implementation, correct?
That's correct. First of all, as far as the endangerment finding litigation, okay, now we just started that litigation February 16th with all these suits being filed. Remember that the endangerment finding is a final rule. While the D.C. Circuit has it under judicial review, it stays in effect. So it's in effect. That litigation usually takes about 2 years. It's a long process, particularly when you got a lot of parties. One option that the parties might have, and I was thinking the other day they might try, is to try to get the court to stay the effect of the endangerment finding pending judicial review. That's something they could try right now. They could try tomorrow. That's hard to do. All presumptions are against you when you try that, but the D.C. Circuit will grant that sometimes. But because Lisa Jackson just sent a letter, which I'm sure you guys are covering, and I know you guys are covering this, Lisa Jackson just sent a letter to Senator Rockefeller a couple of days ago, and she said, well, we're not going to start implementing any stationary source regulations for the next year. I think the fact that she did that is going to take the heat off anybody being able to go in and get a stay pending judicial review, because it's going to be harder to argue that there's some sort of immediate irreparable harm.
Dick Stoll leads the environmental practice at Foley and Lardner, a former EPA attorney as well. Dick, it's always good to have you with us. Sorting through a very complex issue.
Okay.
And thank you for joining us as well. I'm Tyler Suiters. You're watching Clean Skies News.